Welcome to another edition of Disability Insurance Law TV. My name is Gregory Dell, and I'm an attorney with the law firm of attorneys Dell and Schaefer. We are long-term disability insurance attorneys. Today I am joined by attorney Jessup and attorney Cesar Gavidia. And today we are going to discuss the Metropolitan Life Insurance Company, also known as MetLife, and throughout our discussion we will refer to the company as MetLife. Now, the purpose of this video, since we handle long-term disability insurance claims against every disability insurance carrier, is to give you a little bit of a better understanding as to how MetLife handles their disability claims around the country. But before we start to discuss some of the cases around the country against MetLife, I want to speak to you a little bit about who MetLife is and what kind of firepower they have so you know what you're up against. Now, MetLife was a company that was founded in 1868, and they currently have 54,000 employees. They are the second largest group disability insurance company in the entire country. Their revenues last year were $41 billion, and in the most recent quarter, they reported a profit of $833 million. So this company is what I would consider an absolute financial monster. They're a very strong company financially, which is great. You don't have to worry about them going out of business, but you do have to know that if they deny your claim, they have all the resources available in the world to battle you. So let's talk a little bit about some cases around the country that have taken place recently. We are going to discuss individual disability insurance policies which are not governed by ERISA, and then we'll also discuss some cases that are governed by ERISA. And Steve, I'd like to have you start off with a case that you recently came across.
Greg, well, coming across, I found a group policy claim, so it's through your employer, so it's governed by ERISA. On this particular one, I have a gentleman who was worked for a printing company, was in charge of supervising many employees, was responsible for observing the work, checking for errors, all kinds of things, lots of quick movements. There's lots of things going into it. He files this claim for disability, advises MetLife, I'm blind in one eye, I have severe diabetes causing problems with numbness throughout his body and everything. They end up denying his claim in the short run, to the gist of it, they end up denying his claim. And one of the interesting things I found with this, especially in the way that they were reviewing the claim and they were trying to separate all of his disabilities from one another instead of taking a look at it a whole, when hiring their doctors to go and review their medical records, they don't hire anyone that's going to review his condition for his eye, how that would relate, or any of his physical complaints. They basically have doctors review certain symptoms and conditions that weren't necessarily disabling on their own, which was even admitted by his attorneys. At the end of the day, the court almost seems to get disgusted with MetLife in the way that they were handling the claim and says, well, you guys are saying he can go back to work. He's blind in one eye. He can't feel his hands and his legs. He's around moving parts all day. And you have to take a look at, sure, if he goes back to work, he's going to pose a danger to himself, the people he supervises at the printing press, and also, even though his doctors may have said he's improved a bit since he's been out of this situation, so the insurance company used that to deny his claim, the court came back and said, yeah, but you also have to evaluate, well, if we put him back in the situation, back in his environment, will the problems persist? Will they worsen again? So it was just going away about, you have to take a look at everything that's going to be involved. And this is very common in most of the denial letters I'll see on the ERISA group policy claims, where they'll cherry pick. They'll only review certain things. I mean, in this case, they didn't get a job description for the guy. The doctors who reviewed his medical records and said he could go back to work didn't even know what he did for a living. And so this is something you see happen, unfortunately, frequently with them on their group disability handling.
Recently I did some research too on some cases from MetLife in anticipation of today, and I came across a case handled by MetLife in which the person was a market sales manager, and he had been on claim since 1992 for approximately 10 years, and he was diagnosed with lumbar spinal stenosis, which is a serious back condition. He had had back surgeries in 1990, 1992, and 1994, so he had 3 back surgeries. And in 2002, they had some video surveillance and sent him to a functional capacity exam, and then they thought after seeing the video and having the functional capacity exam that he could go back to a sedentary job. The point of this is that the court disagreed with MetLife's position and felt that they acted arbitrary and capricious, which is commonly the standard in an ERISA case, that a company like MetLife, even if you're on claim for 10 years, can still try to deny your claim. And you see that with just about any disability carrier. Just because you get approved for your claim doesn't mean that you're going to continue to get paid for the rest of your life. So here was a case with a person with a really serious back injury, 3 surgeries, chronic pain, who obviously got worse, 6-7 years after his surgery, and yet MetLife one day, 10 years later, says, hey, by the way, we think you can go back to work. So luckily in this case, the court disagreed with MetLife and this person's benefits. Person lived in Ohio, your hometown, and the person was put back in claim. And I think, Cesar, you came across another MetLife case as well?
And you hear the same stories over and over again. And this person, who was working for Eastman Kodak Company, was suffering from chronic fatigue syndrome. He filed a disability claim. MetLife approved him for 2 years, paid him for 2 years, and it seems that after that 2-year period, when it's own occupation, it switches to any gainful occupation after that period. It seems like they just wanted to cut him off at that point, sent him to 2 independent medical physicians, rheumatologists, who opined that there's no objective evidence that he has any restrictions or limitations, or no objective evidence of any muscle disorder or muscle damage or musculoskeletal problems, and that he was essentially capable of performing unrestricted work duties. Well, of course he appealed, because it's an ERISA case, and under ERISA you have to exhaust all administrative remedies and appeal through every level that the plan requires. After denying him at all levels, he and his lawyers brought suit in federal court in New York. Well, the federal court found that it was arbitrary that MetLife required objective evidence on a condition that there is no objective evidence for. It's very similarly to fibromyalgia. They found that it was arbitrary that that MetLife basically ignored all the findings from Social Security, because he was awarded Social Security as well. They remanded the case back down to MetLife to review again and awarded attorney's fees to this person.
So, Cesar, if you could explain a little bit to our viewers, when a case gets remanded, what does that mean?
Well, usually it's remanded with certain instructions. So it means that the court could either say, we're remanding the case and you have to evaluate it and look at it this particular way, or consider this specific evidence. For instance, the Social Security determination, the court basically instructs the insurance company to look at those specific findings and make a determination. And, again, there's never a guarantee that MetLife or whatever insurance company it is, after a remand, is gonna approve benefits. But considering that there's an order from the court, it's pretty likely that the insurance company would likely do the right thing that second time around.